February 3, 1998, Huntsville, Texas. At 6:40 in the evening, the Texas Department of Criminal Justice updates its roster. Carla Faye Tucker's name moves from active to archived. Outside the Walls unit, camera crews from 14 countries wait for the warden's statement. Inside the governor's office in Austin, a stack of clemency petitions sits sealed. 142 applications filed in the previous decade, with exactly 3 granted. The statute promised finality. The docket showed something else. Appeals spanning years, motions filed in multiple circuits, protocol challenges that kept cases open long past sentencing. Tucker's case drew global attention not for the crime alone, but for the question it forced into public view. Can transformation behind bars change a death sentence? Tonight's decision closes one file. It opens a wider conversation about mercy, media, and the machinery of capital justice. The briefing room in the Texas Capitol building held 17 reporters on the morning of February 2, 1998. A spokesperson for the governor's office confirmed that no clemency hearing would be scheduled. The Board of Pardons and Paroles had voted 16-0 against commutation. The decision followed a pattern documented across Texas capital cases. Since 1976, the state had executed more than 150 individuals, with fewer than 5 clemency grants issued during the same period. Carla Faye Tucker was convicted of capital murder in April 1984. The offense occurred in June 1983. Prosecutors presented evidence of a double homicide committed during a burglary. The jury deliberated for 70 minutes before returning a death sentence. Tucker's appellate team filed direct appeals in state and federal courts. Each motion was denied. By 1998, her case had exhausted all standard judicial remedies. Public attention intensified in the months before the scheduled execution. Tucker granted interviews from the Mountain View unit in Gatesville, describing a religious conversion and participation in prison ministry programs. Advocacy groups cited her institutional record, no disciplinary infractions, completion of educational courses, mentorship of other incarcerated individuals, as evidence of rehabilitation. Prosecutors countered that mitigation evidence, while relevant at sentencing, could not override a jury's verdict or mandate executive clemency. Clemency is the power vested in a governor or board to reduce a sentence or grant a pardon. In Texas, the governor may commute a death sentence only if the Board of Pardons and Paroles recommends clemency by majority vote. The process is discretionary, not automatic. Between 1976 and 1998, Texas received more than 300 clemency petitions in capital cases. Fewer than 2% resulted in commutation. Tucker's case drew international media coverage. Religious leaders, human rights organizations, and foreign governments submitted statements urging clemency. Pope John Paul II sent a letter to Governor George W. Bush requesting mercy. The governor's office issued a brief statement declining to intervene. On February 3rd, Tucker was executed by lethal injection at 6:45 in the evening. She was the first woman executed in Texas since 1863, and the second woman executed in the United States since the reinstatement of capital punishment. The case prompted debate about gender and capital punishment. Scholars noted that women represented fewer than 2% of death row populations nationwide, and that executions of women were statistically rare. Defense advocates argued that Tucker's media visibility and the public's discomfort with executing a woman highlighted arbitrary factors in clemency decisions. Prosecutors maintained that gender should not exempt offenders from lawful sentences. In the months following the execution, clemency applications in Texas capital cases continued to follow the same statistical pattern: high volume, low approval rate. The Board of Pardons and Paroles received 73 petitions in 1999. None were granted. The disparity between public calls for mercy and the legal system's response became a focal point in policy discussions about proportionality, mitigation, and the boundaries of executive power. Tucker's case remains a reference point in debates about whether personal transformation can or should alter a capital sentence. The question persists: when rehabilitation is documented, when institutional conduct is exemplary, when the global community urges restraint, does the law allow room for mercy? The Orange County Superior Court unsealed a resentencing order on July 12, 2010. Rodney Alcala, convicted of 5 counts of first-degree murder committed between 1977 and 1979, received a death sentence for the 3rd time. The initial conviction in 1980 had been overturned on appeal. A second trial in 1986 resulted in another death sentence, also reversed. The 2010 trial, held 31 years after the offenses, concluded with a jury vote for execution. Alcala's case became infamous not for the legal outcomes alone, but for a detail that predated the crimes. In 1978, he appeared as a contestant on the television program The Dating Game. The episode aired months before the murders that would lead to his arrest. Video footage of the appearance circulated widely after his conviction, creating a media narrative that emphasized the contrast between his public persona and the violent offenses documented in court records. The trial record documented evidence from multiple crime scenes. Prosecutors presented forensic analysis, witness testimony, and photographs recovered from Alcala's storage locker. The defense filed motions alleging ineffective assistance of counsel during the first 2 trials. The California Supreme Court granted a new trial based on procedural errors, not evidentiary disputes. By the time of the 3rd trial, DNA testing had advanced sufficiently to link Alcala to additional cold cases in New York and Wyoming. Appellate filings in Alcala's case spanned more than 3 decades. The defense argued that prolonged incarceration without execution constituted cruel and unusual punishment. Prosecutors countered that delays resulted from the defendant's own appeals, not systemic dysfunction. The California Attorney General's office noted that the median time between sentencing and execution in California exceeded 20 years, a figure driven by mandatory appellate review, protocol litigation, and resource constraints. Life without parole, LWOP, is a sentencing option in capital-eligible cases, eliminating the possibility of release while avoiding execution. California juries must choose between death and LWOP in first-degree murder cases with special circumstances. During Alcala's 2010 trial, the defense presented mitigation evidence including claims of mental illness and childhood trauma. The jury rejected these arguments, voting for death. The case underscored tensions between media spectacle and legal process. Alcala's television appearance became a focal point in public discourse, overshadowing the procedural complexity of capital appeals. News outlets framed the case as a cautionary tale about hidden danger. Legal analysts emphasized the systemic delays that characterized California's death penalty system. Victim advocates pointed to the prolonged uncertainty faced by families awaiting resolution. By 2021, Alcala remained on death row at San Quentin State Prison. California had not conducted an execution since 2006 due to legal challenges over lethal injection protocols. A statewide moratorium imposed by executive order in 2019 suspended all executions indefinitely. Alcala's case, like hundreds of others, entered a legal limbo where sentences remained in force but could not be carried out. The question persists. When media notoriety shapes public perception more than legal findings, does the trial process retain its integrity, or does spectacle distort justice? The Broward County Circuit Court issued a competency evaluation order on August 15, 2002. Aileen Wuornos, sentenced to death in January 1992 for the murders of 6 men between December 1989 and November 1990, requested an end to her appeals. The court appointed 3 psychiatrists to assess whether she understood the consequences of waiving judicial review. All 3 concluded she was competent to make the decision. Wuornos's case had been litigated continuously since her arrest in January 1991. The defense presented evidence of severe mental illness, including diagnoses of borderline personality disorder and post-traumatic stress disorder. Attorneys documented a history of childhood abuse, sexual assault, and homelessness. The prosecution argued that Wuornos had planned the killings to rob victims and that mental health issues did not negate criminal responsibility. The jury in the first trial deliberated for 90 minutes before recommending death. Warnos was convicted in 5 subsequent trials, receiving additional death sentences. Florida law required automatic review by the state Supreme Court. Appeals focused on competency, ineffective assistance of counsel, and the constitutionality of executing individuals with documented mental illness. Each motion was denied. By 2002, Warnos had spent more than a decade on death row. She gave multiple interviews stating she wanted to die and believed the appeals process was prolonging her suffering. Defense attorneys filed motions to continue litigation despite her wishes, arguing that mental illness impaired her judgment. The trial court ruled that Warnos had the right to direct her legal representation, including the decision to waive appeals. Mitigation evidence includes factors that may reduce a defendant's moral culpability, such as mental illness, trauma, or diminished capacity. Florida law permits juries to consider mitigation when deciding between death and life without parole. In Warnos's trials, the defense presented psychiatric testimony and records of abuse. The juries found aggravating factors, including the number of victims and financial motive, outweighed mitigation. Warnos's case attracted global media attention. The documentary Aileen, Life and Death of a Serial Killer premiered at film festivals in 2003, months after her execution. Public commentary divided sharply. Some viewed her as a victim of systemic failures in mental health care and social services, while others emphasized the lives lost and the violence documented in court. Feminist scholars debated whether gender influenced sentencing, noting that women on death row were disproportionately survivors of abuse. On October 9, 2002, Warnos was executed by lethal injection at the Florida State Prison in Starka. She was the second woman executed in Florida since 1976 and the 10th woman executed nationwide since the reinstatement of capital punishment. Her final statement, recorded by prison officials, lasted 14 seconds. She declined to speak with family members or legal representatives before the execution. The case highlighted unresolved questions about mental health and capital punishment. Defense attorneys nationwide cited Warnos as evidence that the legal system inadequately addressed the intersection of trauma, mental illness, and criminal responsibility. Prosecutors maintained that competency standards were met and that mitigation did not excuse multiple homicides. When documented abuse and mental illness define a defendant's life, does the death penalty serve justice, or does it punish the consequences of systemic neglect? The Los Angeles County Superior Court clerk entered the final judgment on November 7, 1989. Richard Ramirez, convicted on 13 counts of murder, 5 counts of attempted murder, and multiple counts of burglary and sexual assault, received 19 death sentences. The crimes occurred between June 1984 and August 1985. The trial began in July 1988 and concluded in September 1989. Making it one of the longest criminal trials in California history. Ramirez was arrested in August 1985 after a public identification led to his apprehension by bystanders in East Los Angeles. Media coverage during the investigation was extensive. The press labeled him the Night Stalker, a name that dominated headlines and influenced public perception. The trial record documented forensic evidence, including fingerprints, ballistics, and survivor testimony. The defense argued that media saturation prejudiced potential jurors, filing motions for a change of venue. The court denied the requests. The jury selection process lasted 6 months. More than 1,500 potential jurors were interviewed. Many were dismissed after stating they had formed opinions about the case based on news reports. The defense challenged jury instructions related to special circumstances, arguing that the court's language improperly guided deliberations. The appellate record shows the California Supreme Court reviewed these claims and found no reversible error. Ramirez's appellate team filed habeas corpus petitions in state and federal courts. The defense presented evidence of childhood abuse, including documentation of head injuries and exposure to violence. Psychiatrists testified about potential neurological impairment. The prosecution countered that Ramirez understood the nature of his actions and had planned the offenses. The courts upheld the conviction and sentence. California's death row housed more than 600 individuals by the early 2000s. Ramirez remained at San Quentin State Prison until his death from natural causes in June 2013. He never reached the execution phase. Between 1976 and 2006, California executed 13 individuals. Protocol litigation halted executions after 2006, and a moratorium imposed in 2019 suspended all future executions. Special housing units, SHU, are maximum security facilities where death row inmates are held in isolation. San Quentin's death row restricts movement, limits contact with other inmates, and imposes strict communication protocols. Ramirez spent 23 years in these conditions. Defense attorneys argued that prolonged isolation constituted cruel and unusual punishment. Courts ruled that conditions met constitutional standards. The public narrative surrounding Ramirez focused on fear and spectacle. His courtroom behavior, including displaying symbols associated with Satanism, became fodder for sensational reporting. Legal analysts noted that media portrayals often overshadowed substantive legal issues, such as the adequacy of mental health evaluations and the fairness of jury instructions. Victim families attended hearings throughout the appellate process, seeking closure that never arrived. The question remains, when a case becomes a cultural phenomenon, does the legal system respond to the crime or to the public's fear and fascination? The Circuit Court for Prince George's County issued a final order on October 19, 2009. John Allen Muhammad, convicted of capital murder in the October 2002 sniper attacks that killed 10 people and wounded 3 others in the Washington, D.C. metropolitan area, was scheduled for execution by lethal injection. The sentence followed a trial in Virginia Beach where prosecutors charged Muhammad under Virginia's anti-terrorism statute. The jury deliberated for 6 hours before recommending death. Muhammad was arrested on October 24, 2002, along with Lee Boyd Malvo, who was 17 at the time of the offenses. The investigation involved multiple jurisdictions across Maryland, Virginia, and the District of Columbia. Federal authorities coordinated resources, but Virginia prosecutors moved first to trial, citing the state's expedited capital process and broad terrorism statute. The decision to prosecute in Virginia drew criticism from defense attorneys who argued that forum shopping undermined fairness. The trial record documented ballistic evidence linking Muhammad's rifle to crime scenes. Prosecutors presented testimony from survivors and forensic specialists. The defense argued that Malvo, not Muhammad, fired the fatal shots and that Muhammad's role was secondary. The jury rejected this argument, finding Muhammad guilty as a principal. Virginia law permits execution of accomplices in felony murder cases, even if they did not personally kill. Appellate filings challenged the constitutionality of Virginia's terrorism statute, the adequacy of mental health evaluations, and the decision to try Muhammad in a jurisdiction where only 1 of the 10 murders occurred. The Virginia Supreme Court upheld the conviction. Federal habeas review, conducted by the Fourth Circuit Court of Appeals, found no constitutional violations. The U.S. Supreme Court denied certiorari. Muhammad's legal team filed a clemency petition with Virginia Governor Tim Kaine in November 2009. The petition cited evidence of mental illness, including diagnoses of delusional disorder and post-traumatic stress disorder related to military service. Advocates argued that Muhammad's psychological state at the time of the offenses warranted commutation to life without parole. Governor Kaine denied the petition, stating that the evidence did not outweigh the severity of the crimes or the jury's finding of future dangerousness. On November 10, 2009, Muhammad was executed at Greensville Correctional Center in Jarrett, Virginia. He was 58 years old. The execution occurred 7 years after the offenses, a timeline significantly shorter than the national median for capital cases, which exceeds 15 years. Virginia's streamlined appellate process, combined with limited post-conviction review, accelerated the case. Victim families issued statements through a spokesperson. Some expressed relief that the legal process had concluded. Others noted that no resolution could restore what was lost. The sniper attacks had paralyzed the region for 3 weeks, altering daily routines and instilling widespread fear. Law enforcement officials described the investigation as one of the most complex in modern U.S. history. When acts of violence carry political or ideological implications, does the legal response prioritize justice or public safety and deterrence at the expense of due process? The United States District Court for the District of Colorado issued a final ruling on May 8, 2001. Timothy McVeigh, convicted of 11 counts related to the April 19, 1995, bombing of the Alfred P. Murrah Federal Building in Oklahoma City, was scheduled for execution by lethal injection. The attack killed 168 people, including 19 children, and injured more than 600 others. The jury recommended death, and the trial court imposed the sentence on August 14, 1997. McVeigh's trial lasted 6 weeks. The prosecution presented evidence linking him to the rental truck used in the bombing, testimony from witnesses who saw him near the building, and forensic analysis of explosive residue. The defense argued that McVeigh acted in retaliation for federal actions at Waco and Ruby Ridge, framing the bombing as a political statement. The jury deliberated for 4 days before returning a guilty verdict on all counts. Federal capital cases follow procedures distinct from state systems. The Death Penalty Act of 1994 authorized federal executions and established protocols for appeals. McVeigh's appellate team filed motions in the 10th Circuit Court of Appeals, challenging jury instructions, the admissibility of victim impact testimony, and the constitutionality of the federal death penalty statute. Each motion was denied. The U.S. Supreme Court declined to hear the case. In the months before the execution, McVeigh granted interviews stating he accepted responsibility for the bombing and had no regrets. He requested that his appeals be expedited, a decision that drew criticism from defense attorneys who believed additional review was warranted. The Justice Department announced that the execution would take place at the Federal Correctional Complex in Terre Haute, Indiana, the designated site for federal executions. A procedural delay occurred in May 2001 when the Federal Bureau of Investigation disclosed that it had failed to turn over thousands of pages of documents to the defense during discovery. The delay lasted 1 month while attorneys reviewed the materials. The court ruled that the documents did not contain exculpatory evidence and rescheduled the execution for June 11th. On June 11, 2001, McVeigh was executed by lethal injection. He was 33 years old. The execution was the first carried out by the federal government since 1963, when Victor Feguer was hanged in Iowa. More than 200 victim family members and survivors attended the execution or watched via closed-circuit broadcast. McVeigh declined to make a final statement. The bombing remains the deadliest act of domestic terrorism in U.S. history. The Oklahoma City National Memorial, dedicated in 2000, lists the names of all victims. Federal prosecutors described the case as an unambiguous application of capital punishment with overwhelming evidence and minimal mitigating factors. Defense advocates pointed to McVeigh's military service and the lack of comprehensive mental health evaluations as missed opportunities to explore mitigation. When an act of violence targets symbols of government, does the legal response serve justice, or does it become a statement of state power? The Illinois State Capitol hearing room held 47 people on January 10, 2003. Governor George Ryan, in his final week in office, announced a blanket commutation of all 167 death sentences in Illinois to life without parole. The decision followed a 3-year moratorium on executions imposed in January 2000 after evidence emerged that 13 individuals had been wrongfully convicted and sentenced to death. The announcement sent shockwaves through legal and political communities. Prosecutors described the commutations as an overreach of executive power, undermining jury verdicts and disregarding victims' rights. Defense attorneys celebrated the decision as a recognition of systemic flaws in capital case adjudication. Victim advocacy groups issued statements expressing betrayal and anger. Governor Ryan defended the commutations, stating that the death penalty system in Illinois was arbitrary and capricious and could not be reformed. The Illinois moratorium had been preceded by investigative journalism. A series of articles published by the Chicago Tribune in 1999 documented cases in which defendants were convicted based on coerced confessions, inadequate legal representation, or prosecutorial misconduct. Subsequent reviews by the Northwestern University Law School Center on Wrongful Convictions identified additional errors, including false testimony from jailhouse informants and flawed forensic evidence. Between 1977 and 2000, Illinois executed 12 individuals. During the same period, 13 death row inmates were exonerated and released. The ratio, more exonerations than executions, became a focal point in the national debate over capital punishment. Governor Ryan appointed a commission to study the death penalty system. The commission's report, issued in April 2002, recommended 85 reforms, including improved legal representation, stricter standards for witness testimony, and mandatory recording of interrogations. The commutations applied to all death row inmates, regardless of individual case facts. Some had filed appeals based on actual innocence, others had exhausted all legal remedies and were awaiting execution dates. The decision was categorical, not case by case. Legal scholars debated whether such a sweeping use of clemency was consistent with constitutional separation of powers. Illinois courts upheld the governor's authority, ruling that clemency is a discretionary executive function not subject to judicial review. Clemency rates nationwide remain low. Between 1976 and 2020, governors granted clemency in fewer than 3% of capital cases. The Illinois commutations represented an outlier, a systemic intervention rather than individual mercy. No other state has replicated the action. Illinois abolished the death penalty in 2011. Governor Pat Quinn signed legislation removing capital punishment from state law, citing the same concerns that had motivated the moratorium. All former death row inmates remained in prison, serving life without parole. The Illinois experience influenced policy debates in other states, including Connecticut, Maryland, and New Mexico, all of which subsequently abolished capital punishment. The question endures. When systemic error is documented, does wholesale clemency restore justice, or does it bypass accountability for individual cases? The Dallas County District Attorney's Office issued a press release on September 14, 2009. A man who had spent 17 years on death row in Texas was exonerated after DNA testing excluded him as the perpetrator of a 1992 sexual assault and murder. The announcement followed a review initiated by the District Attorney's Conviction Integrity Unit, established in 2007 to investigate claims of wrongful conviction. The original trial lasted 4 days. The prosecution's case relied on eyewitness testimony from a single individual who claimed to have seen the defendant near the crime scene. No physical evidence directly linked the defendant to the offense. The defense requested DNA testing of biological evidence collected at the scene, but the trial court denied the motion, ruling that the evidence was insufficient to warrant testing. The jury deliberated for 3 hours before returning a guilty verdict. The defendant was sentenced to death. Post-conviction DNA testing became available through legislative reform. Texas enacted a statute in 2001 allowing convicted individuals to petition for DNA analysis of evidence not tested at trial. The defendant filed a motion under the new law. The district attorney's office agreed to the testing. Results obtained in 2008 excluded the defendant and matched an unknown individual in a national criminal database. The case was one of 18 exonerations in Dallas County, resulting from DNA testing conducted between 2007 and 2010. The county's high exoneration rate drew scrutiny. Investigations revealed that the Dallas Police Department crime lab had used outdated testing methods and failed to preserve evidence properly. Administrative reviews led to policy changes, including mandatory recording of interrogations and blind lineup procedures. The exonerated individual was released from custody on September 14, 2009. He received no compensation from the state for the years spent on death row. Texas law at the time did not mandate payment for wrongful convictions. Advocacy groups lobbied for legislative change. In 2009, Texas enacted the Tim Cole Act, which provided compensation of $80,000 per year of wrongful incarceration and access to tuition assistance and health care. Nationally, more than 180 individuals have been exonerated from death row since 1973. The leading causes of wrongful convictions in capital cases include eyewitness misidentification, false confessions, inadequate legal representation, and prosecutorial misconduct. DNA testing, when available, has been the most reliable tool for identifying errors. The Dallas County case underscored the limitations of the original trial process. Eyewitness testimony, long considered reliable, has been shown to be fallible. Studies conducted by the Innocence Project found that eyewitness misidentification contributed to approximately 70% of wrongful convictions later overturned by DNA evidence. Courts have responded by implementing new safeguards, including expert testimony on the reliability of eyewitness identification and revised jury instructions. When scientific advances reveal error, does the legal system adapt quickly enough? Or do institutional barriers delay justice for those wrongfully convicted? The Ohio Parole Board hearing room in Columbus held 12 people on March 22, 2014. The board convened to consider a clemency petition filed on behalf of a man sentenced to death in 1995 for a double homicide. The petitioner's legal team presented mitigation evidence not introduced at trial, including childhood trauma, documented brain injury, and intellectual disability. Victim family members testified in opposition, describing the impact of the crimes and their belief that the sentence should be carried out. The hearing lasted 3 hours. The defense submitted neuropsychological evaluations, school records, and affidavits from family members. A forensic psychiatrist testified that the petitioner's IQ fell below 70, meeting clinical criteria for intellectual disability. Defense attorneys argued that the trial court had failed to adequately consider mitigation and that the jury was not informed of the full extent of the petitioner's cognitive impairments. Atkins v. Virginia, decided by the U.S. Supreme Court in 2002, prohibited the execution of individuals with intellectual disability. The ruling required states to establish procedures for determining disability. Ohio adopted a standard requiring proof by a preponderance of the evidence. The petitioner's trial predated Atkins, and no intellectual disability evaluation was conducted at the time of sentencing. The defense argued that new evidence warranted clemency as a remedy for the trial court's oversight. The prosecution countered that the petitioner had functioned independently before his arrest, holding employment and managing daily activities. A psychologist testifying for the state questioned the validity of post-conviction IQ testing, suggesting that malingering or coaching could skew results. The board heard testimony from corrections officers describing the petitioner's conduct in prison, which included participation in educational programs and compliance with facility rules. The Ohio Parole Board voted 7-2 to recommend against clemency. The majority opinion stated that mitigation evidence, while relevant, did not outweigh the severity of the offenses or the jury's finding of aggravating circumstances. The board noted that intellectual disability claims had been raised in post-conviction proceedings and had been adjudicated by state and federal courts, which found that the petitioner did not meet the Atkins standard. Governor John Kasich reviewed the board's recommendation and declined to grant clemency. The petitioner was executed on April 16, 2014. Defense attorneys issued a statement expressing disappointment and reiterating concerns about the adequacy of intellectual disability evaluations in capital cases. Clemency hearings nationwide follow inconsistent procedures. Some states provide formal hearings with testimony and cross-examination. Others rely on written submissions reviewed by a board or governor without public proceedings. The absence of uniform standards creates disparities. In Ohio, between 2000 and 2020, the parole board recommended clemency in fewer than 10% of capital cases. Governors granted clemency even less frequently, approving fewer than 5% of applications. When mitigation evidence emerges after trial, does clemency provide a safety valve, or does procedural finality foreclose meaningful review? The California Department of Corrections and Rehabilitation published its annual report on December 31, 2019. The state's death row population stood at 737 individuals. No executions had been carried out since January 2006. Litigation over lethal injection protocols had stalled the process for more than a decade. On March 13, 2019, Governor Gavin Newsom issued an executive order imposing a moratorium on all executions, citing concerns about the fairness and accuracy of capital convictions. The moratorium did not commute existing sentences. All death row inmates remained under sentence of death, held in maximum security facilities with restricted privileges. The executive order stated that no execution warrants would be signed during the governor's term in office. Legal challenges to the moratorium followed. Prosecutors in several counties filed suit, arguing that the governor had exceeded his authority by suspending sentences imposed by juries. The California Supreme Court upheld the moratorium, ruling that clemency is an executive prerogative. California's death penalty system had been subject to repeated legal challenges. In 2014, a federal district court ruled that the state's system of capital punishment violated the Eighth Amendment due to excessive delays and arbitrary application. The ruling was overturned on appeal, but the underlying issues remained unresolved. The median time between sentencing and execution in California exceeded 25 years, far longer than the national median of 15 years. The cost of maintaining California's death penalty system drew scrutiny. A legislative analysis conducted in 2011 estimated that the state spent more than $150 million annually on capital cases, compared to approximately $11 million for life without parole cases. The disparity was driven by mandatory appellate review, post-conviction litigation, and the expense of housing death row inmates in specialized facilities. Public opinion on the death penalty in California shifted during the 2010s. A ballot initiative to abolish capital punishment, Proposition 62, appeared on the November 2016 ballot. The measure failed, receiving 46% of the vote. A competing measure, Proposition 66, which sought to expedite executions, also appeared on the ballot and passed narrowly. Subsequent litigation blocked implementation of Proposition 66, leaving the system in limbo. Governor Newsom's moratorium applied to all individuals on death row, regardless of offense or procedural history. Some had been sentenced decades earlier. Others had exhausted all appeals and were awaiting execution dates. The moratorium created a paradox. Sentences remained in force, but no mechanism existed to carry them out. Victim. Families expressed frustration, stating that the legal process had promised closure but delivered none. California's experience raised a fundamental question. If a sentence cannot be carried out, does it retain meaning, or does it become an indefinite punishment without resolution? The United States Supreme Court issued its opinion in Kennedy v. Louisiana on June 25, 2008. The court ruled by a vote of 5-4 that the Eighth Amendment prohibits the execution of individuals convicted of child rape when the crime did not result in the victim's death. The decision invalidated capital statutes in 6 states, Louisiana, Texas, Oklahoma, South Carolina, Montana, and Georgia, that authorized execution for aggravated sexual assault of a minor. The case originated in Louisiana, where Patrick Kennedy was convicted in 2003 of aggravating rape of his 8-year-old stepdaughter. The jury recommended death, and the trial court imposed the sentence. Kennedy's appellate team argued that the punishment was disproportionate under the Eighth Amendment's prohibition of cruel and unusual punishment. The Louisiana Supreme Court upheld the sentence, finding that child rape warranted the death penalty due to the severity of harm inflicted. The Supreme Court's opinion analyzed evolving standards of decency. Justice Anthony Kennedy, writing for the majority, noted that only 6 states authorized execution for non-homicide offenses and that no individual had been executed for child rape since 1964. The court concluded that a national consensus had emerged against capital punishment for crimes not resulting in death. The opinion emphasized that the death penalty must be reserved for the most serious offenses and that proportionality requires a nexus between the punishment and the taking of life. The dissent, written by Justice Samuel Alito, argued that the majority's consensus analysis was flawed. The dissent pointed to recent legislative activity in the 6 states as evidence of a trend toward expanding capital punishment, not restricting it. The dissent also noted that child rape inflicts profound and lasting harm and that states should retain the authority to determine appropriate penalties. The decision had immediate effects. 49 individuals on death row in Louisiana and Texas for non-homicide offenses were sentenced to life without parole. The ruling foreclosed the possibility of executing individuals for aggravated sexual assault, regardless of victim age or injury. Defense attorneys hailed the decision as a recognition of proportionality principles. Prosecutors and victim advocates criticized the court for limiting state authority and disregarding the trauma experienced by child victims. The Kennedy decision joined a line of Supreme Court cases narrowing the scope of capital punishment. Atkins v. Virginia, 2002, prohibited execution of individuals with intellectual disability. Roper v. Simmons, 2005, barred execution of individuals who were under 18 at the time of the offense. Together, these rulings reflected a judicial effort to align the death penalty with constitutional standards of proportionality and human dignity. When harm is severe but does not result in death, does proportionality demand a limit on punishment, or does the law undervalue certain victims by restricting penalties? The United States Department of Justice issued a press release on July 14, 2020. The federal government had resumed executions after a 17-year pause, carrying out the sentence of Daniel Lewis Lee at the Federal Correctional Complex in Terre Haute, Indiana. Lee had been convicted of 3 counts of murder in Arkansas in 1996 and sentenced to death under federal law. His execution occurred at 8:07 in the morning, following an overnight legal battle that reached the U.S. Supreme Court. The decision to resume federal executions was announced in July 2019 by Attorney General William Barr. The Justice Department adopted a new execution protocol using a single drug, pentobarbital, replacing the 3-drug combination previously used. The change followed litigation over the constitutionality of lethal injection methods, which had delayed executions for nearly 2 decades. Defense attorneys challenged the new protocol, arguing that it violated federal administrative law and posed a risk of pain and suffering. The Supreme Court ruled 5-4 that the executions could proceed. Between July and December 2020, the federal government executed 10 individuals. The pace was unprecedented. No federal executions had occurred since 2003, when Lewis Jones was executed for kidnapping and murder. The 2020 executions took place during the final months of the Trump administration. President Donald Trump had campaigned on expanding use of the death penalty, and the Department of Justice moved quickly to carry out sentences. The resumption of federal executions drew criticism from multiple quarters. Civil rights organizations argued that the executions were rushed and that procedural safeguards were inadequate. Religious leaders, including the U.S. Conference of Catholic Bishops, issued statements opposing the executions. Victim families in several cases submitted letters requesting that the sentences not be carried out, stating that execution would re-traumatize them rather than provide closure. Legal challenges focused on competency, proportionality, and the adequacy of clemency review. In one case, defense attorneys presented evidence that the defendant had suffered severe brain damage and lacked the mental capacity to understand the reason for his execution. The trial court stayed the execution, but the Supreme Court reversed the stay, allowing the sentence to proceed. In another case, the only Native American on federal death row was executed despite objections from the Navajo Nation, which opposed capital punishment as inconsistent with tribal values. The 10 individuals executed in 2020 had spent an average of 21 years on death row. All had exhausted direct appeals in post-conviction review. Clemency petitions were submitted to the Department of Justice's Office of the Pardon Attorney. All were denied. President Trump did not grant clemency in any capital case during his term. When political priorities drive execution schedules, does the legal process retain its deliberative character? Or does speed compromise justice? The Oklahoma Department of Corrections issued an internal memorandum on October 28, 2021. An execution scheduled for October 26th had been delayed after prison staff were unable to establish an intravenous line for lethal injection. The condemned individual, John Grant, was eventually executed after a delay of more than 1 hour. Witnesses reported that Grant vomited and convulsed during the procedure. The incident reignited debate over execution protocols and the competence of personnel administering lethal injections. Oklahoma had resumed executions in October 2021 after a 6-year moratorium. The state had halted executions in 2015 after a series of botched procedures. In 2014, Clayton Lockett died of a heart attack 43 minutes after the start of his execution, after the execution team failed to properly insert an IV line. Witnesses described Lockett as writhing and gasping. The incident led to an independent review, which found deficiencies in staff training, drug procurement, and protocol design. The Oklahoma moratorium was lifted after the state adopted a new protocol. The revised procedure used a 3-drug combination: midazolam, a sedative, vecuronium bromide, a paralytic, and potassium chloride, which stops the heart. Defense attorneys challenged the protocol, arguing that midazolam did not reliably render individuals unconscious and that the subsequent drugs caused excruciating pain if awareness persisted. The U.S. Supreme Court ruled in Glossop v. Gross, 2015, that the protocol was constitutional, finding that the inmates had not proven the availability of an alternative method that posed less risk. Grant's execution was the first in Oklahoma since the moratorium ended. Witnesses included media representatives, state officials, and victim family members. Reports indicated that Grant spoke during the procedure, complaining of discomfort. The execution team consulted with a physician before proceeding. Grant was pronounced dead at 4:21 in the afternoon. An autopsy conducted at the request of defense attorneys found no evidence of improper drug administration, but noted that the delay in establishing IV access was consistent with prior issues identified in the 2014 review. Subsequent executions in Oklahoma proceeded without major complications, but questions about protocol reliability persisted. In November 2022, an execution was stayed minutes before the scheduled start after prison officials discovered they had prepared the wrong drug. The error was attributed to inadequate labeling and storage procedures. The state attorney general's office issued a statement pledging to review all protocols. Oklahoma executed more individuals per capita than any other state between 1976 and 2020. The state's aggressive use of capital punishment, combined with its troubled execution history, made it a focal point in national debates. Defense attorneys argued that the frequency of procedural failures demonstrated systemic incompetence. Prosecutors maintained that isolated errors did not invalidate the overall system. When execution procedures repeatedly fail, does the state's authority to carry out sentences remain legitimate? Or does technical incompetence undermine the legal foundation of capital punishment? The Death Penalty Information Center published its annual report on December 31, 2023. 11 individuals were executed in the United States during the year, the lowest number since 1988. 5 states carried out executions: Texas, 3, Missouri, 2, Oklahoma, 2, Florida, 2, and Alabama, 2. No federal executions occurred. The decline reflected a long-term trend. Execution rates had fallen by more than 70% since the peak of 98 executions in 1999. Multiple factors contributed to the decline. 33 states had abolished the death penalty or imposed moratoriums. Juries in capital-eligible cases increasingly chose life without parole over death. Pharmaceutical companies, responding to pressure from advocacy groups, refused to sell drugs used in lethal injections, forcing states to seek alternative sources or methods. Legal challenges over execution protocols created delays. Public opinion shifted. National polls showed that support for the death penalty had declined from 80% in the mid-90s to 55% in 2023. The number of death sentences imposed also fell sharply. In 2023, juries returned 21 death sentences nationwide compared to more than 300 annually in the 1990s. Prosecutors exercised discretion to seek life without parole in cases that previously would have been charged capitally. Defense attorneys presented mitigation evidence more effectively, and jurors appeared more receptive to arguments about mental illness, trauma, and intellectual disability. Geographic concentration of capital punishment increased. Between 2020 and 2023, more than 70% of executions occurred in 5 states: Texas, Oklahoma, Missouri, Alabama, and Florida. Other states with active death penalty statutes carried out no executions during the period. The disparity highlighted inconsistencies. Identical crimes resulted in different outcomes depending on jurisdiction. A defendant charged with capital murder in California faced decades of appellate review and no realistic execution date. The same defendant in Texas might be executed within 5 years. Victim perspectives remained divided. Some families advocated for execution, viewing it as necessary justice. Others opposed capital punishment, stating that execution prolonged trauma and prevented healing. Organizations such as Murder Victims' Families for Reconciliation brought together family members who had lost loved ones to violence and opposed the death penalty. The group's message emphasized restorative justice over retribution. The 2023 report noted that 2,004 individuals remained on death row nationwide. Many had been there for decades. The average time between sentencing and execution exceeded 20 years. Defense attorneys described the prolonged appeals process as a form of additional punishment. Prosecutors argued that delays resulted from defendants' own motions, not systemic failures. The final line of the report cited a docket entry from the Southern District of Texas, dated December 15, 2023. Case closed. Sentence carried out per court order. The entry appeared on page 312 of the annual federal docket, a single line among thousands. No commentary, no explanation, just the record preserved.